Hello everyone, welcome to Gurulkan Checkers YouTube channel. Today we are going to talk about types of employment contract in Turkey. In principle, an employment contract is not subject to a specific form, unless otherwise regulated by law. Therefore, an employment relationship based on a verbal agreement or even implicit, non-verbal mutual understanding is permissible. In cases where there has been no written contract concluded between parties, the employer is obliged to give employee a written document specifying the essential terms and conditions of the agreement. Such documents should be given within 2 months following the commencement of work. According to the law regarding compulsory use of Turkish language in commercial enterprises, a contract must be executed in Turkish language in the event that a Turkey-based commercial entity is a party to it and it is performed in Turkey. An employment contract does not necessarily have to stipulate the length of employment, validity period, or the date of expiry. Where the contract is not made for a certain period of time, it is considered to be concluded for an open-ended period. On the other hand, fixed-term contracts are made for a specified period or a specific event, the duration of which can be objectively determinable even though not expressly set out in the contract. It is worth pointing out that open-ended contracts grant broader rights to employees compared to fixed-term contracts. In principle, the duration of a work can be a maximum of 45 hours a week in full-time employment. In addition, employees can work overtime based on grants of national benefit, nature of work, or increasing productivity. Overtime work is defined as the work exceeding 45 hours a week. Overtime pay per hour to be given to an employee shall be at least 50% higher than the normal hourly pay. The employment contract shall be considered as part-time contract where the normal weekly working time of the employee has been fixed considerably shorter compared to an equivalent employee working full-time. Part-time work period cannot be prescribed more than 2/3 of full-time work. Thus, a part-time employee can be employed for 30 hours a week at the utmost. Organizations usually employ on-call workers during special events, peak hours, or intermittently when business needs require additional support. On-call employment contracts must be made in written form. In case the length of work time has not been determined by parties, the work time is deemed to have been fixed as 20 hours per week. Trial period clauses in employment contracts help parties to get to know each other and foresee whether they are willing or unwilling to sustain their contractual relationship. Turkish law allows trial period clauses to be set forth in any and all types of employment contracts. The duration of trial period cannot exceed 2 months. Such period can be extended up to 4 months in collective labor agreements.